Welcome to Criminal Law Video Presentation number 9. This video will discuss felony murder. At common law, if you remember, malice aforethought essentially contains 4 elements: the intent to kill, the intent to inflict great bodily harm, abandoned and malignant heart, that is, reckless indifference to unjustifiable risk to human life, and the 4th, felony murder. This video is going to discuss the 4th of these malice aforethought components, that is, felony murder. So let's take a look at it. This is an example of felony murder, the idea of malice aforethought being felony murder. Our gunman here says, "This is a stick-up, give me your money." The gun goes off, he shoots the hapless victim. The victim then dies. And the gunman says, "I didn't intend to shoot him." Classic example of felony murder that we're going to look at. So let's take a look at it. The first thing that will stand out about felony murder is that it is a strict liability murder. That is, the defendant must be found guilty of the felony, that is, the underlying felony. In our previous example, it would have been robbery. And the killing must occur during the commission or the attempted commission of the felony. Deaths while fleeing are considered to be during the commission of the felony. There is no mens rea required for causing the death. The only mens rea that is needed is just for the felony. So you see why it is said to be a strict liability murder. Now, there are various statutory schemes as to how felony murder is played out. Many or most of them will create first-degree murder with certain enumerated felonies. It's usually arson, rape, burglary, kidnapping, robbery, and there are a variety of others that various states will throw in there. Everything from child endangerment to carjacking to terrorism. There are a variety that states have added. And usually then second-degree murder are all other felony murders. And again, this varies by jurisdiction. Because felony murder is a strict liability offense, where one can be convicted of murder, even first-degree murder, under strict liability concepts, the various jurisdictions have gone about limiting felony murder, and there are essentially 3 basic limitations that we'll talk about on this video. That the first one is that jurisdictions will limit felony murder to inherently dangerous felonies. Now, there are 2 ways that jurisdictions go about deciding this. The first is how California does it, and other jurisdictions, is to look at the felony statute, the statute that is the underlying predicate for felony murder, and look at that statute in the abstract. That is to say, can the offense be committed in a manner that is not dangerous to human life? If a court looking at the statute can conceptually come up with a way that the offense can be committed without causing danger to human life, that court will find that it is not an inherently dangerous felony and therefore not a predicate felony for felony murder. And you will see this in your casebook as you read People versus Howard. Another way to look at this is as it occurs. A number of jurisdictions look at the facts to determine if the felony is inherently dangerous. So they'll look at the statute, but they will also look at the facts as it occurs to see if those facts present an inherently dangerous scenario. And if they do, they will find that it is an inherently dangerous felony and can be used as a predicate to felony murder. And there are a number of jurisdictions that designate certain felonies as inherently dangerous. And these jurisdictions go felony by felony, designating certain ones as inherently dangerous felonies. The second limitation that is often imposed by jurisdictions is the independent felony limitation. That is, the predicate felony must be independent of the killing. If not, it merges and there's no separate murder. The best example that one could give is voluntary manslaughter. You could find that a defendant who meets all the elements of voluntary manslaughter has committed a felony, obviously voluntary manslaughter. And then if that felony were used as a predicate felony for felony murder, which would raise voluntary manslaughter at least to second-degree murder, you would never have the offense of voluntary manslaughter. It would always be a predicate felony for felony murder, and therefore every voluntary manslaughter would be subject the defendant to a conviction of second-degree murder. This would be an absurdity, as you can see. So voluntary manslaughter cannot be the predicate felony for felony murder. It must be independent of that. California, for example, looks at assaultive offenses. If the only underlying felony is an assaultive offense, if the only part of that felony is committing an assault on another and for some reason the victim of the assault dies, then the court will not find it to be an independent felony. There is an exception here, and the court looks to see if there is an independent felonious purpose. The best example of this will be the robbery that we saw earlier. There are two felonious purposes that go on in a robbery. One is the act of taking the victim's property, simple larceny in and of itself, and the second one is assaulting the victim, putting them in fear in order to commit the larceny. In that instance, courts will often find that there is an independent felonious purpose to commit the theft independent of the assault, and that will be sufficient for an independent felony and permit a conviction for felony murder. The third limitation is the killing by a non-felon, and there are essentially two rules that play out. The majority rule, which is the rule in almost all jurisdictions, is that only deaths caused by one of the felons will be sufficient for a conviction of felony murder, and you'll see how this plays out in a minute. The second rule is the proximate cause rule. That is, all deaths that proximately result from the commission of the felony will be sufficient for the predicate underlying felony for felony murder. So, the proximate cause rule, as I said, is only in a few jurisdictions, and Ohio does something peculiar. Ohio, by statute, imposes the proximate cause rule on the felony murder statute. This doesn't apply to aggravated murder. This is only for murder, and it says that no person shall cause the death of another as a proximate result of the offenders committing or attempting to commit an offense of violence that is a felony of the first or second degree. So Ohio does something different, and we'll talk about this more in class by layering in the proximate cause rule into the felony murder rule. So let's take a look at how this agency proximate cause rule plays out. So the agency rule says that the felons have to cause the death of another during the commission of a felony. So we've got felon A and felon B. We've got victim, who the felons are committing a felony on, and the police, who come to the scene. Now, in this scenario, felon A shoots the victim, or felon A shoots the police officer, or felon B shoots the victim, or felon B shoots the police officer. In all of these instances, felony murder will apply, and the agency rule will permit conviction under the felony murder rule, because both felons have either caused directly the death of the victim or the police officer. So this is a simple playing out of the agency rule that felon A shoots and felon B can be convicted because felon B is deemed to be an agent of felon A, or felon B kills and felon A can be convicted because felon A is deemed to be an agent of felon B in this circumstance, and the agency rule will permit conviction. Let's take a look at it happening now another way. Felon A shoots felon B, or felon B shoots felon A. Again, in this instance, the felony murder rule will permit conviction under the agency theory. Now we'll take a look at a third scenario. In this instance, the victim shoots felon A, the victim shoots felon B, or the victim shoots the police. And it could also occur with the police coming on the scene and shooting the victim, or shooting felon A or felon B, or an innocent bystander. Again, any one of these scenarios. What you've noticed here is that neither the felon A nor felon B has directly caused the death of another. It has been done by either the victim or the police, or could even be a third party coming in to prevent the felony. But what's significant here is felon A and felon B have not directly caused the death. In this instance, based on the agency rule, there is no felony murder. Felony murder is not permitted in this instance as a strict liability offense. However, felony murder could be found under the proximate cause rule. And again, remember, the proximate cause rule is the minority rule and doesn't exist in most jurisdictions. The prevailing rule is the agency rule. So in most jurisdictions, in this scenario, felon A and felon B could not be convicted based on felony murder. However, in Ohio, for murder, because it's a proximate cause state, they could be convicted. This concludes this brief video on felony murder. As always, you need to go to the Twin site and fill out the assessment for video 9, felony murder. Thank you.